Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe and hit the notification bell. It really helps the channel grow. For today's case, we're dealing with an update in the Trendmood versus Samantha Rabinowitz case. As we covered last time, Trendmood is a company that deals with beauty, and Samantha Rabinowitz is a person who deals with tea, and they have come into conflict. Trendmood has sued Samantha Rabinowitz for a whole bunch of things that she has said, alleging that they now amount to defamation and other tortious action. So in today's response, Rabinowitz says, okay, how about an anti-slap motion? So she is saying, okay, under California law, this is protected speech, and you can't sue me for this. And as the court will note in its discussion, apparently, at least in the Ninth Circuit, California anti-slap can be used in a California federal court. Not always, but at least in this case. So we're going to cover this response on this anti-slap. We're going to assess the merits of it and see what chances are for Trendmood and Rabinowitz's. We're here for the tea. Let's get started with this. Rabinowitz's writes, California-based plaintiff Trendmood, which claims to be highly popular and successful health, beauty, and cosmetic influencer, is abusing the court system by pursuing this patently meritless libel lawsuit against Canadian citizen Rabinowitz. With its defamation action, Trendmood seeks to punish Rabinowitz's for various legitimate criticism she has published online about the company and its principal during its years. Brought primarily to chill the defendant's valid expression of free speech, Trendmood's retaliatory litigation is a classic example of a strategic lawsuit against public participation, a slap. As such, it is proper to dismiss under California's anti-slap, which applies in federal diversity cases such as this. So right away, we've got the tone of this thing completely set out. I am merely a critic and a notable critic of Trendmood, as I have a right to be. And Trendmood is merely doing this to suppress valid free speech and to stop public participation. And at least in California, apparently, you can bring the California state anti-slap into a federal court in California. So apparently you can do that. So we're going to ask for attorney's fees and all the rest of it. So what is our basis for asking for those things? Let's read some more. Trendmood asserts subject matter jurisdiction based on diversity of citizenship. California's anti-slap statute applies in federal diversity cases such as this. Because it is in the public interest to encourage continued participation in matters of public significance, and this participation should not be chilled through abusive process, the section in California law is to be construed broadly. When a diversity defendant brings an anti-slap motion in the Ninth Circuit District Court, she may elect to attack the challenge pleading either on its face or factually based on sufficiency of evidence. You know, just for sake of absolute clarification here, when it says when a diversity defendant, because the word diversity can mean a couple different things, right? So the reason that this is diverse has nothing to do with race or creed or color or any of those things, right? That's not the sense of diverse. We're talking about diversity jurisdiction, which in this case means that they are in two different states or two different places, right? One person is in Canada. One person's in the United States. Those are definitely different. So it's diverse because different geography. So the word diverse here shouldn't be understood to apply to race or any of those things. It's not diverse in that sense. If a defendant makes an anti-slap motion to strike founded on purely legal arguments, analysis is made under rules of 8 and 12 standards. If it's a factual challenge, the motion must be treated as a motion to dismiss. Because Rabinowitz chooses the former, and hereby moves to strike based on alleged deficiencies, the motion must be treated in the same manner as 12b6. So Rabinowitz says, okay, under the relevant law, I can do this two different ways. I can say, okay, purely legal arguments, then this standard. If I'm challenging the facts, this standard. So I want to convert this into a motion for summary judgment and get judgment based on a factual record. Okay. All three of the counts levied against Rabinowitz by Trendmood are variation of claims that she defamed the company online with her November 12th, 2020 tweet. I don't know if that's a fair characterization. I seem to remember that Trendmood was bringing up other things other than this one tweet. So I'm not sure that's a fair characterization of what Trendmood was writing. They continue, this is a paradigm example of exactly the sort of case based on alleged conduct in furtherance of exercise of constitutional rights of petition or constitutional right of free speech in connection with public issues or issue of public interest falling within the ambit of an anti-SLAPP. Taken together, the legislative history and subsequent case law surrounding the California's anti-SLAPP statute demonstrates that a public issue or issue of public interest within its meaning necessarily includes any interest in which the public is interested. In other words, the issue not need be significant to be protected by anti-SLAPP. It's enough in which the public takes interest. So apparently in California says a public issue is any issue in which the public is interested. So that's pretty broad, right? Any interest in which the public is concerned. California courts have not hesitated to conclude the following are encompassed, even though they might be trivial topics, because the public is interested. So here are some things to which SLAPP and anti-SLAPP law have applied. Cat breeding, dating, plastic surgery, a shopping mall, prurient offenders, sports medicine, and insurance settlements. Some of those are not necessarily public in a traditional sense, but if the public's interested, yeah. And then they write, with these principles in mind, it's clear plaintiff's cause of actions arise from protected activities by the anti-SLAPP. So this is of public interest at least as much as these other ones are. Fair enough. Trendmood alleges that Rabinowitz has, for years, been an outspoken critic of the company and its chief marketing officer, publicly questioning Trendmood and business practice and beauty operations, while at the same time frankly conceding that Rabinowitz's online comments were likely protected by free speech on the First Amendment. Trendmood nevertheless admits that it previously sought to chill vocal public challenges last year by having its counsel draft and send Rabinowitz's a cease and desist letter, which defendant then published on the internet for the world to see. So I actually liked this from Trendmood. I thought this was a good strategy. Trendmood themselves acknowledged there was a whole bunch of speech that was protected, and then argued some other speech at some point started crossing the line into the unprotected. I thought this was a very good strategy because it shows that they understand the difference and that it's not merely, they're at least projecting to the court that they appreciate there's a difference between protected speech and unprotected, which I think is probably a pretty good thing to do, personally. So they conceded, and I think it's a sharp move. So Trendmood says, yeah, this was a whole bunch of protected speech, and then says it also sent a cease and desist. Right, because we thought you crossed the line. So this rebuttal is kind of conceding the central structure. So I'm not really sure this is really doing anything in terms of the analysis, but we thought important to mention for some reason. Consequently, Rabinowitz's November the 12th, 2020 tweet at issue qualifies as both a communication made in a place open to the public or a public forum in connection with an issue of public interest, and conduct in furtherance of a constitutional right of freedom of speech in connection with this, and of Section 4 of the relevant law. Trendmood's entire action ultimately appears to be founded on a claim that Rabinowitz's libeled the company via its tweet when on November the 12th, the defendant falsely accused Trendmood of engaging in a doxing campaign against her and violating multiple sections of California's penal code and potentially federal law. That was what the amended complaint said, that they doxed and they accused us of violating the law. Okay. As belied by the very exhibit, however, Rabinowitz has plainly never, in fact, said any such things. The court will readily observe that Rabinowitz does not in reality use the word doxing at all. She never said anything about California Section 653.2 or any other provision of the penal law, federal statutes, stalking, cyberstalking, or criminal law. Rather, those are Trendmood's own words, which is erroneously misattributing to Rabinowitz. Okay, so this is an interesting idea here, and it's an interesting way to try to characterize what's happening. So Trendmood is saying in their complaint, she said these things. These things amount to or would result in these things. So Trendmood's argument isn't that she used the word dox, for example. Trendmood's argument is that whatever words she used, that is equivalent to doxing. So she may not have used that word, but she invokes the concept. She may not have ever said that they're violating a particular law, but the words that she used would suggest violations of law. Okay. And then Rabinowitz says, well, no, that's not the words I used, right? So you're reading into it more than I said. You're trying to extract meaning that's not there on its face, which is a perfectly valid argument, right? Because you either have the meaning on its face, and if you're going to go to the next step of, well, this is the inferred meaning of a reasonable person, right? Then you have to actually go show that. And Trendmood, it just allegates it at this point. They haven't really gone to show that a reasonable person would necessarily interpret this way. And so Rabinowitz is going to say, okay, here's exactly what I said, and here's why a reasonable person would or would not interpret it the way that you're trying to interpret it. Perfectly solid legal theory. All Rabinowitz herself is alleged to have actually written is that Trendmood is giving out my personal information, which is relatively innocuous, an equivocal assertion open to a rather broad interpretation. A libel which is defamatory of the plaintiff without necessity of explanatory matter, such as inducement, innuendo, or extrinsic fact, is said to be libel on its face. Right, so if we don't need explanation, like an inducement, innuendo, or some intrinsic fact, if we don't need something external, then it's internal, which means it's there on its face. Because Rabinowitz's alleged statement that plaintiff was giving out her personal information standing alone is not immediately defamatory, without the aid of further explanation, it does not constitute libel per se. Also, okay, so Rabinowitz says, Trendmood is giving out my personal information. That's what she actually wrote. Trendmood is giving out my personal information. Trendmood says, you're accusing us of doxing. Rabinowitz says, I'm not accusing you of doxing. I'm accusing you of giving out my personal information, which may or may not be the same thing, depending on what you think doxing is, which is also a somewhat open term. So, is giving out personal information the same thing as doxing? I guess it depends a little bit on what you think doxing is, which isn't exactly like codified anywhere. I don't think that there's some statute somewhere that actually defines doxing. Now, there's statutes out there that define various crimes, but I don't think they actually call it doxing. So, is giving out someone's real name doxing? Yeah, because you could have all kinds of things that are or not doxing. What is the line, right? So if you have a person who's anonymous or pseudonymous, if you say their real name, is that doxing? Does it matter if they actually say their own name or not? Is it only doxing if that information is not disclosed by them? Is it doxing if you repeat information that they disclose? What exactly is doxing? Which information counts as doxing? If you find publicly available information, like an employee directory, and you say, well, here's an employee directory, is that doxing? What exactly are the lines here, right? So we could have a fight over that, I suppose. She actually said giving out personal information. Trendmood says doxing. And then she says, well, those are not the same thing. I'm not so sure, man, because they're both kind of vague and open terms. But she wrote what she wrote. So you can't say doxing when all I said is personal information. Are those distinct? You can decide for yourself. Whether a statement can reasonably be given any defamatory meaning is a legal question that must be resolved by determining the sense or meaning of the statements under all circumstances attending to publication, according to a natural and popular construction, which would ascribe to them by the average reader. So this is one of those reasonable man tests, right? So this is a legal test, and the court is going to ask a witness whether or not what this means, right? And what witness are we going to ask? Well, we're going to ask the reasonable man, which is a construction in our mind, right? That's who we ask about these questions. We ask the reasonable man, the ordinary prudent man, the person of reasonable intelligence and observation skills, the man on the bus. That's who we ask. We ask that guy. And so the court constructs this theoretical person, the ordinary man of normal conscience and ordinary prudence. And we say, hey, reasonable man, how would you read this? How would you understand it? What is a natural and understandable reading of this? And then we go on and we ask that question. Whatever the reasonable man says, which again is a construction in our own mind, becomes the right answer. Okay, fine. Rabinowitz's words here merely reflect the belief that Trendmood had communicated some unspecified personal information, which could mean any one of innumerable things. Literally anything from defendant's ethnic identity or eye color to her favorite color or even favorite flavor of ice cream. Which, again, given the loose definition of the word doxing, I don't know, someone somewhere probably considers it doxing to tell someone's favorite color of favorite flavor of ice cream. If Trendmood and or some third parties unaffiliated with Rabinowitz somehow independently interpret the tweet, they necessarily instead refer to personally identifiable information or personal identifying information, as that legal term of art is used in California's doxing statute. Their unilateral understanding is certainly not attributable to the defendant who never wrote such a thing. Okay, so in the relevant California statute, which defines doxing apparently as a term of art, so I guess I have to correct myself from earlier when I said I was unaware of such a thing, because apparently California actually has a section called doxing. But whatever. In this section called doxing relates to personally identifiable information or personal identifying information. And I merely said you gave personal information, which is distinct from personal identifiable information or personal identifying information. Is that distinct enough to draw a distinction between as a matter of law? I'm not sold. I'm not personally sold. If you're going to say personal information is different than personally identifiable information or personal identifying information, that's a little thin for my taste. But I'm not going to slice it quite that thin for me. Rabinowitz cites a relevant case. Such hair-splitting analysis of language has no place in law of defamation, dealing as it does with impacted communications. It is inconsistent with the rule that publication is to be measured not so much by the effect, when subjected to critical analysis of a mind trained in law, but natural and probable effect on the reasonable mind of the reader. And then she concludes by saying, because Rabinowitz's Twitter post is not reasonably susceptible of defamatory meaning, fails to state a claim of relief. See, I go exactly the opposite way on this one. I go the opposite way. I agree with the legal rule, right? A hair-splitting analysis has no place in law of defamation, right? So we're not going to turn this on the thinnest reeds of language, right? So that's the relevant standard. Then Rabinowitz says, oh, because that's the standard, what I wrote is not reasonably susceptible to defamatory meaning. But it's only not susceptible to defamatory meaning if you're going to split the difference between personal information and personally identifying information or personally identifiable information. That's the difference you have to split. She actually wrote personal information. The relevant law prohibits personally identifying information. And then she says, wait, hair-splitting analysis has no place in the law of defamation. And so clearly what I said is not defamatory. See, I go exactly the opposite way. Citing the exact same citation. It's like, yeah, we don't slice it quite that thin. If you're going to try to slice the difference between personal identifying information and personal information as distinct concepts, I think that's a fairly hair-splitting analysis of language. And we have no need for that in defamation. And so if we have no need for it, that means that they're the same thing. If they're the same thing, then that's a defamation, if it's not true. So I think her analysis kind of cuts against her conclusion, at least in this legal interpreter's opinion. As discussed in the section above, the plain language of the tweet is not libelous on its face. I disagree. I don't think that's right. Defamatory language not libelous on its face is not actionable unless the plaintiff alleges and proves they suffered some special damage as a proximate result. The requirement is especially strong when, as here, the plaintiff is not a natural person capable of suffering dignitary or emotional harm, but rather a corporation whose only conceivable damages could be money, which I'd like to note does not have a citation to it. So we're saying the requirement is strong when this is true, and there's no citation. Are we just making that up, or do we have authority for that proposition? I'm not saying that there's not authority for that proposition. I just note there's no citation. The rote formulaic resuscitations of injury set forth in count 2 come nowhere close to the exacting level and detailed specificity that would be required in order for them to state a libel per quad. I'm not so sure about that one. You gave out personal information, and splitting the difference between that and you are doxing. I don't know, man. That's striking a little thin. Thus, even if November the 12th, 2020 tweet was found to be responsible for tortured interpretation alleged by Trendmood, the first amended complaint would nonetheless still state no cognizable claim upon which relief could be granted due to its wholesale failure to allege special damages in any more than a conclusory pro forma terms. All right, so then we're gonna go on to a different things because we spent all this verbiage so far on whether or not it is defamation on its face or not, right? So I'm not sold on this argument that it's not defamation on its face. We're having to slice it a little thin, and it's too thin for my taste, particularly in light of the case law, which says not to slice it this thin. So I'm like, okay, this argument does not sell me. I think it's libelous on its face. Okay, but that of course doesn't stop the analysis, right? We have to ask other legal questions. So let's ask the next legal question. All right, let's see if that changes the answers. Self-proclaimed as a viral sensation and one of the most recognized internet influencers in the world, Trendmood is clearly a general or at least limited purpose public figure. Well, right away, we're off to a much more promising start. Right? We're off to a much more promising start. Yeah, Trendmood says we defamed them, we didn't fame them. I'm like, I think you did. Well, how about this? What is the standard we have to prove for defamation, right? Because it's defamatory on its face, but what is the relevant standard? Well, they self-proclaim themselves as a viral sensation and one of the world's most important influencers. Sounds suspiciously to me like you're claiming to be a limited purpose public figure. You know, one of those times when bragging can actually can undo you, right? We are so big, we're so popular, look how big we are. Okay, yeah, that's a lot more promising. As a public figure, it would have to plead and ultimately prove in its liable action that Rabinowitz has published her defamatory tweets, knowing it was false or reckless disregard. Fair. As with respect to special damages, Trendmood's only allegation regarding the issue constitutes bare recitation of the elements of actual malice, unsupported by any facts. Such conclusory contentions alone are insufficient under modern pleading standards. Yeah, you can't just say, here is the law, which is basically what she's saying that they did. It's like, here's the law, right? You have to show this, this, and this. And then she says, but you didn't actually show any facts to that. You just said, here's the law. You have to actually say, here is facts that support that legal conclusion, which you didn't do. Yeah. Instead, a public figure plaintiff must plead plausible grounds to infer actual malice by alleging enough facts to raise a reasonable expectation discovery will reveal evidence of actual malice. Yeah, that's right. You know, you can't go into a fishing expedition into discovery. You can't get into discovery to go looking for stuff hoping it's there. You have to have some evidence it's there. It's like you have to have some evidence that there's some fish in this pond before you're allowed to go fish in the pond. That's basically some evidence that there's fish there. How do you know that there's fish there? Oh, I just want to go fish there. No, you can't do that. So she's saying, well, you didn't make enough facts to show that I did this with actual malice, and you're a public figure. So why do you think that I was recklessly disregarding? Fair. You know, fair arguments, much better. The mandatory attorney's fee provision in the California Antislapp statutory scheme is available to defendants in federal diversity cases. She will subsequently bring a regularly noticed motion to recover fees and costs after this motion has been granted and Rabinowitz has been deemed a prevailing defendant on special motion to strike. So she can get attorney's fees if she wins the slap. I'm not so sure so will she win the slap or not? Well, I guess it depends how good the allegation as actual malice is. Because that's going to turn a lot. And whether or not they still have the ability to amend, whether or not they can amend their complaint, and whether or not the court wants to allow them to amend, and whether or not they can is a practical matter amend. Do they have the ability to amend? Just because you can amend doesn't mean that you have what you need. You have to actually be able to write things. If you can't write those things, then whether you have the right to amend or not, it's kind of irrelevant. So do you have specific reasons to believe that she is recklessly disregarding the truth? I don't know about that one. So her ability to win the anti-slap? It depends, I suppose, on the court's analysis, but yeah, it's not looking too bad. The court may dismiss a complaint that fails to state a claim upon which relief can be granted. In analyzing the motion to dismiss, the complaint must contain enough facts to state claims to relief that's plausible on its face and raise that right of relief to the above a speculative level. This may be at the speculative level, particularly when it comes to the actual malice thing. A plaintiff claim that meets the plausibility threshold by pleading factual content that allows the court to draw a reasonable inference. That's going to be a problem. Is there enough factual content? to draw a plausibility threshold for the actual malice thing. I don't seem to remember that in the complaint. Nothing pops into mind, so there might be a problem there. So we'll see how that response is going to go. Thus, that brings us to the end of the special motion to strike in the case of Trenmood versus Samantha Rabinowitz. In this case, Samantha Rabinowitz is accused of saying some defamatory things. And Samantha Rabinowitz says, I didn't really say those defamatory things. First of all, she says this is all about one particular tweet. I'm not sure that's necessarily true. Second, as to that particular tweet, she says, I didn't say docs. I said personal information, which is totally distinct from personally identifiable or personally identifying information. Those are totally different things without having to go to slicing the difference so thin that you can see through it. Not sold. Kind of think those are the same thing. I kind of think that personal information and doxing are equivalent for the purposes of this exercise. Not sold on that. However, her next argument's much better. They're a public figure, and they didn't make the allegations to show actual malice. Much more promising. So we'll see how Trenmood responds. We'll see if they want to allege specific things and why they think that they have it, or whether or not they think the standard applies at all, which given they themselves describe themselves as the world's most renowned beauty, whatever, yeah, they kind of put themselves into public figure status. So that's going to be a hard sell. So hopefully they're able to say why they think that this is clearly actual malice or reckless disregard. So we'll see how the case proceeds, but at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.